Hello, everyone. Thank you for joining to this part. In the previous part, we discussed about the industrial dispute. And in the industrial dispute, one of the informal way of settling the dispute is called collective bargaining or negotiation. Now, as we have seen the procedure for that, so the next question comes that if the parties do not agree to the settlement, they are supposed to settle, assuming that a party noticing the either party about industrial dispute and the other party accepts that yes, there is an industrial dispute. Then they thought that let's sit together and find out the solution, so they sit together. However, when they sit, uh, it is very usual that they will come to an agreement, but they could not come to an agreement because the other party was not in a mood or position to agree with the terms and conditions. Or when one of the party, when we talk about party, we mean two things. First, the employer. Second, the CBA. So when either a CBA or the employer write a letter to the other party that an industrial dispute exists, so that the other party finds it and did not give any reply or did not respond, that means there is no meeting at all. Now in those situations, uh, if I mean, this is what subsection 4 of section 210 talks about, that after the receiving communications they fail to arrange a meeting, or they could not settle after their sitting uh, within a period of 1 month from the date of their first meeting, or they took further time. So basically what happens is that the parties under any circumstance could not come to an agreement, which is mentioned in subsection 3 as an outcome of the collective bargaining process, or as an outcome of the negotiation process. Then what will happen? So if they fail, then any of the parties may, within 15 days from the expiry of the period, uh, or within 15 days from what they talked about in subsection 2, which is they will try for an agreement within 15 days of receipt of communication, but they fails. So they took time and they could not come to any conclusion. Then the matter shall be reported to the conciliator. Uh, so who is a conciliator? Basically, uh, if you can recall the previous lecture in subsection 3, when both parties agreed to the dispute settlement issue, they will send one copy to the conciliator. Now, if they cannot agree, if they cannot come to any conclusion, if they cannot reach to any solution, then the point is what they will be doing. So it says that, I mean, this section says that if they fails to, in this regard, they are supposed to communicate to the conciliator that they have failed to settle the industrial dispute by themselves, or they could not come to any agreement. So then they will request the conciliator in writing to settle the dispute. So the conciliator, within 10 days after receiving such a request, proceed to conciliate in the dispute. So this is what the conciliator is supposed to do. He will settle the dispute within, he will proceed to conciliate in the dispute within 10 days after receiving the request. The conciliator shall make the parties understand that what will be the ultimate result if they settle the matter between them, and what will be their loss or what will be their gain if they go to the court. So conciliator will approach them about not to continue with the disputes, rather to be agreed upon and settle amicably. Now, subsection 5 says that the government shall, by notification in the official gazette, appoint such number of persons as it considers necessary as conciliator for such specific area or any industrial establishment or industry, and the conciliator shall take up the conciliation to whom the request shall be made for conciliation under subsection 4. So basically, conciliators are people or officials appointed through the official gazette of the government for a particular area to pick the conciliator, and that's how they are designed. Usually, first class government officers are bestowed this responsibility or task. So the conciliator then, after receiving the request of conciliation from the parties, shall start the conciliation and call a meeting of the parties to the dispute for the purpose of bringing about settlement. So the approach of conciliator is indicated in subsection 4, stating that the conciliator will actually approach the parties to come to certain agreements to amicably settle the dispute, and also describe the parties. If they continue with the dispute and then try to go to the court, then certainly that is not going to help them. Rather, that is going to bring negatives, in the sense that they have to spend money, they have to spend their time, and they will still remain in the uncertainties about whether they are going to get the outcome in near future. So the parties to the dispute shall appear before the conciliator in person. Once the conciliator will call them and arrange for a meeting, or there are options for the parties to be represented by nominated individuals, and authorize those nominated guys to negotiate and enter into agreement. So because if you talk about the employer of industries, they are quite busy. They have so many burdensome assignments to function. I think which is one of the reasons that they do not get enough time to, or they will naturally not be able to attend in the conciliation process in person, considering their range of, engagements in the dispute settlement in the industrial functions, for which the law has allowed the representation mechanism. Through the representatives, the conciliator shall be able to the conciliator shall be able to continue the functions on behalf of the employers. Their authorized persons will be there. So that's how the CBA and the employers will be attending the meeting of conciliation before the conciliators. Now it says that if any settlement of the dispute is arrived at in the course of the proceedings before the conciliator, then the conciliator shall send a report thereof to the government, together with a memorandum of settlement signed by the parties. However, if no settlement is arrived within a period of 30 days from the date of receipt of request under subsection 4, the conciliation proceedings shall be considered as failed, and there can be a situation that within the 30 working days, within a period of 30 days, the party could not actually come to any conclusion through the conciliators, but the conciliator is of the view that if they get another 1 week time, then they will be able to settle the dispute. Now, if such kind of situation emerges, then it is very much possible that they can take time more than 30 days. So they can take further time if by writing to the conciliators or by agreeing upon their writing. So the point is, after the time, the need for conciliation, they utilized the time and then they agreed that there is no settlement. They could not settle. The conciliator is also convinced that approaching these parties is not going to help. It is a very waste of time. Then he will consider that this conciliation process has failed. So first it was collective bargaining or negotiation. Secondly, it is conciliation. Conciliator will take 1 month time from the date of the parties written him to conciliate. The conciliator, assuming that failed within this time, or even he allowed the parties for some further time, but again they could not come to any solution, so then it will be presumed that the conciliation process is failed. Now, what will be happening afterwards? That's a very crucial question, and we will be discussing about that in the next part. Thank you for the attention.